Your Lordship.
Notice for delivery of judgment. I got 54.
Is allowed.
Item number 55.
Prayer for bail is allowed. Yes.
Your Lordship. Item number 10, Lordship. This criminal petition is become infructuous as
Item
final
number,
report
as stated by learned counsel for the petitioner. You are?
for the petitioner.
Your name?
And so to
Accordingly dismissed as such. Yes.
What did I make a statement? Published.
Maybe I make I don't know 34, my lord. CD is not available, my lord.
34. Okay, so you did not receive list again, no?
Interim may be continue. Always.
May I please, Your Lordship? Item number 27, my lord. CD up to date CD has not received my list.
No, did not update. And let the CD for updation.
To date CD.
Why? Interim madam,
Raise the matter again on
interim madam, I will continue, my lord. Interim order, my lord.
interim.
Obliged.
I beg to mention, Your Worship, item number 26, Your Worship. He was called for, that is not received, Your Worship. There is an interim that may be continued, Your Worship.
Interim order passed earlier to continue.
Interim order may be continued. I love.
Please, Your Lordship. I beg to mention for item number 30, Lordship. Prayer for withdrawal, Lordship.
You are?
And a begum for petitioner, Lordship.
Then on the prayer of Miss N.A. Begum, learned counsel for petitioner. Is dismissed as withdrawn.
Item 30.
Something discuss.
Oblige, Your Lordship.
Right, please, Your Lordship. I would like to mention item number 20. Kindly pass over it for it.
Prayer of learned counsel for the petitioner.
And Lordship, I would also like to mention for urgent listing of criminal petition, kindly allow it on 29th of January.
Right?
20, we have received the case, so we have to retain it. 20, we have received.
Yes, there will be retained.
20 item, mine item is item 57, Lordship. My matter may be taken, Lordship, today.
57. All right, 57.
Wait, please, Your Honor. I beg to state for item number 9. The charge sheet has already been filed in the matter. Kindly allow us some time to file an additional affidavit. Item number 9.
Prayer of learned counsel for respondent.
Petitioner.
Petitioner. Taking time to file additional affidavit. List the matter again on.
May I please, Lordship? Lordship, I beg to mention item number 48, Lordship. Youngest counsel has some difficulties, Lordship, may pass over from it. Time.
48.
Lordship, 48, Lordship.
You know.
Lordship may fix it after 4 weeks, Lordship. Deeply applies, Lordship.
Please, Your Lordship, I beg to mention item number 12. Respondent number 2. And the matter was actually part heard in Honorable Justice Pranjal Das's court, sir. And we request it might be put up there itself. And it may be adjourned for today. We have the consent of the other side.
Submitted by learned counsel appearing for the respondent number 2.
Yes, S. Hussain.
This matter is part heard before another bench within bracket. is the matter accordingly. This is item 12.
Yes. Obliged.
May I please?
The prayer of Mr.
P. Das.
Das matter is dismissed as withdrawn.
Pleasure.
May I please, Your Honor?
Yes.
There is an application under section 483 BNSS. What's it, the brief fact of the case is that on 2012-25, S.I. Abdul Rahman of Deopa Outpost under Morini Police Station lodged an FIR at Morini Police Station stating that the acting upon reliable source information regarding the operation of an organized gang of burglars within the jurisdiction
Alright,
of Morini
CD.
Police Station.
11-2.
Here, Your Lordship, the petitioner is behind bar for 67 days, Your Lordship. And in fact, Your Lordship, after going through, Your Lordship, I have found that, Your Lordship, these are all 60 days offense, Your Lordship. Charge sheet has not been submitted yet, Your Lordship. FIR, Your Lordship, will get it at page 14, Your Lordship. In this particular case, 67 days. Otherwise, Your Lordship, he is behind bar for more than 80 days, Your Lordship.
You mean to say the sections are 60-day offenses?
60 days offense.
All the sections?
All the sections.
Yes,
Once-
PP.
Okay. Perfectly instruction whether charge sheet is submitted or not. At true lordship.
All right.
Lords. Deeply obliged.
Regular drill, my lord. I am in jail for my lord 36 days. I am a student, my lord. I am only 19 years old, my lord. Although there is no direct allegation against me, but my handshake was used by one of my friend, my lord, inserting his, my lord, SIM card, my lord. That is the allegation, my lord. Page 11, my lord, Annexure 1. That is the FIR, my lord. My whole case is, my lord, paras 7, 8, and 9, my lord, of my petition. And FIR was closed after 5 days, my lord. My lord, immediately he did not oppose the police, my lord. Your lordship kindly see. There are 7 and 8 my case, my lord.
All right, we'll have the CD.
He may short date, my lord, only 36 days in jail, my lord.
Offense is serious. These kind of offenses are on the rise. Yes.
My lord, actually, he is
Short
victim
date.
of circumstance, my lord.
Srirang, 9-2.
My lord, deep look.
Yes, the petitioners behind the bars, more than almost 1 month, my lord. And they have no fault, my lord. In this regard, my lord, the informant himself stated that he was sustained injuries, my lord. Well, kindly have a look at page 23. This is the medical, my lord, report. Page 23, my lord. Medical report. My lord, there is no injury marks, my lord. And even, my lord, the petitioners have, my lord, sustained injuries, my lord. There's page 21, 22. This is the, my lord, medical report, my lord. Or a petitioner. And page 23, my lord. This is the medical report of the, my lord, informant, my lord. He has not sustained anything. Even he beaten us, my lord. And to cover up the said, my lord, he lost his affair. But almost, my lord, 1 month behind the bars, my lord. He confirmed public servant was assaulted by. There are no injury marks, my lord. Page 23, my lord, kindly have a look, my lord. We sustained injuries. Even a quarrel took place between the petitioners and one of the subject person. And, my lord, he came to the skin, my lord, and assaulted us, my lord. And to cover up the said assault, my lord, he lost his affair. Page 20 is, my lord, no injury, no external injury or any abnormalities found, my lord. Even, my lord, he is alcoholic, my lord. Page 22. As page 21 and 22, my lord, we sustain injuries, my lord. And further, no fault, my lord, almost 1 month, my lord, behind the bars. All young boys, my lord, students. There's some minor interaction took place between the one shopkeeper and my lord petitioners. He came to the spot and assaulted us. Almost 1 month, my lord, behind the bars, my lord, no, maybe, my lord, further custody, my lord. Cannot be required, my lord. We are, my lord, cooperating with our investigation, my lord.
Who is the informant?
Gokul Rajmukhi,
The policeman.
the policeman, my lord. The page 20 was the, my lord, medical report, my lord. Almost 1 month, my lord, no, my lord. Further custody may not be required, my lord.
Yes, PP.
Is that assaulting a public servant by detracting his duty only? Yeah, otherwise, injury sustained by him after receiving the case die, it will produce. Lordship, I leave it to you.
He has no sustained any injuries, my lord.
Heard learned counsel for the petition and learned additional PP. An application under so and so. As per the allegations, the complainant, who is a police personnel,
Home guard, my lord.
who is a home guard, was on duty at Patharquari traffic point. He was called by a woman to break up a fight between the accused persons. Upon his intervention, the accused persons chased him and assaulted him. The result of which the government sustained serious injuries. Full stop. The petitioners were arrested the spot by traffic personnel. On
On the same bed, no. Forwarding on male 2/1/26. Just forwarded on that 2.
1-1. Okay. Arrested on 1-1.
1/1.
1-1-26. And since then, they have been behind bars. The perusal of the medical report annexed to the instant bail application in respect of the informant does not disclose any external injury or any abnormality on physical examination. Having regard to the above as well as the period of detention, the prayer for bail is allowed. 3,000, 1 security each with the investigation.
Diplomas. But here is the case, matter. There is a love affairs between them, my lord. And due to matter religious matter differences, my lord. There is no POXO, my lord. And my lord, they are behind the bars for more than almost 15 days, my lord. And kindly have a look at page D and Annexa D, my lord. Page 18 onwards, my lord. These are the, my lord, electronics, my lord, social media exchanges, my lord.
Let
That-
try to
that-
reject the prayer of bail or
that law-
monetary statement recorded.
Hmm?
As per praise of the case diary and monetary statement, Lanet try to reject the prayer of the bail. So
All-
CGBP
PD
record for
That's ordinary, my lord.
10 to.
Diplomas.
Fifty-seven, Lordship, we have received the case diary, I don't know, 20 was.
Lordship, in this case, what happened, Lordship, total 4 accused person were arrested, Lordship, and except me, Lordship, all other accused person has been released on bail, Lordship. And M20 also that I have seen that in the lower court, they have, the learned court has granted bail, Lordship, whatever it is. Considering the length of detention, Lordship, here the Lordship punishment is maximum 7 years, Lordship, and today is the 45 days, Lordship, I am behind the bar, Lordship. This accused, 3 accused person has been released on bail, Lordship. Today is the 45 days, Lordship. And Lordship, item has also been recovered, Lordship, stolen item, Lordship. I have annexed the seizure list, Lordship.
Why did you not go there?
Lordship, I had earlier went there, Lordship, but I have, along with all other accused person, rejected, Lordship. Second time they have appeared, they have approached the learned court below, but I was not aware, Lordship. I have approached before this now court, Lordship. I have annexed that rejection order initial, Lordship, on the ground that the investigation is initial stage, so Lordship, at that stage, Lordship, bail may not be granted, Lordship. At page 20, Lordship, I have annexed that order, Lordship. Subsequently, they have approached again, Lordship, before the learned court below, but I had no knowledge. I have appeared before you, Lordship. I have approached before you, Lordship, by this petition, Lordship.
He's the owner of a truck, Lordship, and in his truck, he loaded the stolen articles and sold it and another person, Shah Jahan, in Sober Enterprise. And materials were recovered from that scrap.
The person from whom, Lordship, the stolen item was recovered, Lordship, he was also granted bail, Lordship, in bail application 18 of 2026. So, Lordship, considering length of detention, Lordship, and nature of case, Lordship, I may be allowed to go on bail, Lordship, at this stage. Since all other accused person has been released also, Lordship. Namely, Lordship, the length of detention may be considered, Lordship. Maximum period of punishment is 7 years, Lordship. Today is, Lordship, 45 days, Lordship.
One person, main accused Shah Jahan Ali, is yet to be arrested and The recovery of the JCB vehicle is not to be recovered yet, Lordship.
The arrested persons has been released, Lordship. I am paying Lordship on the paying Lordship length of detention, Lordship. It is 45 days, Lordship. It is available, Lordship.
Shahjahan Ali.
Israelis at page 26, Lordship. Items were recovered from one Saber Ali, owner of this cab dealer.
He is the person who delivered the materials on that scrap.
You are the thief.
Lordship,
Thief is, one person is Shahjahan Ali, he is yet to be arrested.
considering the length of detention, Lordship, or to me go on bail, Lord. Yeah, another arrested person has been arrested on the same day, Lordship. Released on bail, Lordship.
CD is updated up to when?
It is updated. P1,
Hmm?
P1 25.
They were released on bail on 12/1/26. 25, no 26.
P1, P1 26. Three, we have to look at this. P1 26.
With had learned counsel for the petitioner. Additional TP. An application under so and so. The brief of the case is that the brief of the case as per the FIR is that the sales of PWD department had removed some cattle traps at VIP Road, Guwahati, and replaced them with concrete slabs. The removed cattle traps were kept on by the roadside, were subsequently stolen, carried away, one dumper and one truck. The basis of information, the police arrested the present petitioner 14/12/25 at Pamohi, and he led the police to another co-accused, namely to the shop of another co-accused, Shaber Ali, where the stolen articles were recovered, which were already converted to smaller pieces. In this regard, besides the petitioners, 3 other persons were also there. Appears that the other co-accused persons, namely Shaber Ali, Sahil Ahmed, and Shaber Ali, Sahil Ahmed, and Subur Bhuya, granted bail by the learned additional session judge, Kamrup Metro, by order dated 12/1, orders dated 12/1/2026. Primarily considering the nature of the offense and length of detention. Full stop. The present petitioner has spent 45 days behind bars, keeping the principle of parity in mind. The prayer for bail is allowed considering the nature of the offense as well as the length of detention. Accordingly, it is directed that the petition so shall be released on bail of is 40,000. With one surety each of like amount, subject to the satisfaction of the learned Dhaka magistrate, subject to the following conditions. I cannot lead him. Bail petition stands allowed a copy.
I'm deeply obliged, Lordship. Obliged, Lordship.
Please, Your Lordship. Anticipated the bail application, there are 3 numbers of petitioners. FIR is at page 17. It's a translated copy, vernacular is at page 23. Basic allegation is that there are 10 numbers of accused in this FIR, Lordship. Kindly note the date, 13/9/2025. In the evening, the informant has alleged that in the evening, the accused person entered into her house and with some weapons and physically assaulted them, and thereafter they sustained some injuries and they were admitted to hospital by 108. There are 10 numbers of accused. All the family members of the petitioners has been made accused in this FIR. In fact, the actual fact is that we have also lost an FIR, which is at page 11. Our FIR is prior. They lost the FIR on 13/9. We lost the FIR on 12/9. Our FIR is at page 11. Vernacular is at page 13. May I read the FIR? The petitioner number 2 had lost this FIR. And in fact, the petitioner number 2 sustained some injuries also. And the medical documents are page 15 and 16. Bezera Samuhik Sastho Kendra.
It was rejected by session judge earlier.
Yes. Regarding lodging of our FIR has not been considered. In fact, we had been advised to, it's been referred to GMC and AIMS. The whole, the FIR dated 13/9/2025 is a counterblast to our FIR, in fact.
That may be so, but after perusing the CD, a prayer was rejected, so we'll have to see the CD.
Till then, interim may be granted.
No question.
Till then, protection may be granted.
CD, date.
12 to 26.
Yeah, lordships. My lord, one minor incident, my lord, where my lord information herself responsible for that, my lord. Now, my lord, it's become my lord political and my lord communal colors, my lord, they have given. Can I look at page 8, my lord? The FIR, my lord. And my lord, this informant, my lord, herself is responsible for the incident, my lord. And one of his cousin, my lord, was injured, my lord. Even my lord, he is nowhere at that place of occurrence, my lord. The petitioner, my lord. Petitioner is, my lord, is a General Secretary of the my lord, Youth Congress, and he's busy in some other places at that point of time, my lord. Later, my lord, he came, and this informant has my lord, there the public gatherings has took place, my lord, and my lord, he is the only known face, my lord, of that gathering, my lord. That's why my lord, his name has been indicated. Even my lord, I am my lord, ready to my lord cooperate with the investigation, and I am the General Secretary of the Youth Congress, my lord. My lord, your lordship may protect me, my lord, and I'll cooperate, my lord, and after the provisional city, my lord, your lordship, my lord, consider my beneficiation after that.
I think we had this yesterday or same CD, same incident.
Maybe, my lord, some other persons were arrested. His father, even his father is also arrested, my lord. This Joyson Hazarika, my lord, his father, he's also arrested, my lord.
May not have sent back the CD. I think it was yesterday or day before.
Yesterday was accident case was here, lordship.
Hmm?
Yesterday accident case was here, lordship, but whether it is this case or not,
FIR is the same, I remember.
yes.
I think there were two cases.
I am ready to cooperate, but I am the General Secretary of the my lord, Youth Congress. At that point of time, I was not present, but
See if the CD is there, still there. We can have it after some time.
diplomas.
Please, your lordship. So in this case, FIR is at page 11, lordship. There is some land dispute, lordship, between the informant and accused number 1, lordship. Accused number 1 is not before your lordship. FIR is at page 11. Petitioners are the neighbors, lordship. Specific allegation is against the accused number 1, lordship. Collected in the order passed by the learned court below, lordship. Page 20 is the order passed by learned court below rejecting the bail of the accused number 1, lordship. Page 20. And 21 is the lordship recording about statement, lordship, under 183, lordship, BNF. Page 21, lordship, middle paragraph, lordship.
It can be called for district, lordship.
They are not the family members, lordship. They are the only neighbors, lordship, who tried to stop the scuffling, lordship. And the one accused was arrested and he was released on bail. He is also the family member of the informant, lordship. Land dispute, lordship, among themselves. Petitioners are 4 in number. They are the neighbors only, lordship. Another order is at page lordship 20 lordship. 19 is also a lordship. Specific allegation against Habibur Rahman lordship. He has not approached.
Allegation is against whom? Habibur.
Habibur lordship. Both the orders reflect like that lordship. Section 183 lordship.
Habibur is the informant.
Habibur is the informant. Two
Yes.
Habibur lordship. One is Habibur lordship, one is Habibur lordship, son of a different lordship. Habibur is the informant, Habibur is the lordship, accused number 1 lordship.
Name is same and spelling.
Hmm?
Spelling is same also.
Also, only father name lordship maybe. I guess
This is the PS case number.
PS case number lordship,
Hing 30925.
309, being 30925 lordship.
What is this order? This is
Lordship,
High
will find
Court
lordship.
order.
Page 18 is the 30925 lordship.
Page 24.
24 was earlier round of litigation among themselves lordship. Earlier also lordship, this same dispute was there. And these family members were granted earlier occasion lordship. We are not lordship there. Page 20 is also the 309 lordship.
Third learned count the petition. Additional PP or application under so and so. Case is that page 21. Call for the CD. During the fact that is situated co-accused person was granted bail by the learned additional session judge number 4 FTC. Nagaon. By order dated 8/1/26 in DA case number 1984 within bracket capital N stroke 825. Of the CD. Granted prior bail.
This one regular lordship.
Huh?
Page 20 is the regular one and
Bail. Provided that the petitioners in the event of their arrest shall be released on interim bail of rupees 50,000 like amount. The arresting authority in connection with the aforesaid case. It is further provided that the petitioner shall appear before the IO within a period of 7 days. You know,
18-2.
right.
May it please your lordship. Lordship, may I pray, let this matter be taken up tomorrow, lordship. Because my,
prayer of tomorrow may not be possible.
Matter is delayed, already matter is delayed. So many dates have been taken. Let the matter be taken.
because there's a civil suit and as well as lordship criminal proceedings, lordship,
Yeah,
that's why the lordship. Tomorrow, any day, lordship. If possible, lordship tomorrow. Because otherwise TCR is here, lordship may be fixed for the final hearing, lordship.
What is then the challenge here?
A challenge, Lordship, they have filed a complaint petition. I am the accused, their Lordship. They have said, Lordship, by some fake document, Lordship, the mutation has been done, Lordship. They have challenged the title should there also, Lordship. Now, they have gone for such Lordship of this document, Lordship, police such that house of this petitioner, nothing of such a document, Lordship, recovered from the house of this petitioner, Lordship. Is the case, Lordship.
So let us fix it for hearing then on a fixed
Yes,
date.
Fixed it.
Great. Heard learned counsel for both sides. TCRS call for has been received. Matter is admitted for hearing. Lays the case for hearing on even date.
20. Publish. Lordship, I have an unusual pair regarding item 30, Lordship. There is a anticipatory bail, Lordship. I have a item at court number 6, Lordship. May I pray, Lordship, let the entry may continue. Case study has not come, Lordship.
Not come.
Item
Not received.
Receive list again on so and so interim order passed earlier to continue.
31, Lordship. Highly obliged. Wait. 18-2. Obliged. 31.
This was 31.
31, Lordship.
31.
Anticipated bail, Lordship.
31.
Lordship, this matter may be password for time being, Lordship. 13.
Lordship, I am for the respondent. We'll file a affidavit, wakalatnama, and we need some time to file a opposition, Lordship.
Lordship, for some time, Lordship. Kindly, Lordship.
These 4 weeks, Lordship.
Anyway, they have appeared for the first time today. What is to do?
Kindly for some time, Lordship. After 10-15 minutes, Lordship.
All right.
Please, Your Lordship. The matter where the petitioner is appearing in person, I was appointed as an amicus to assist this honorable court. In the last occasion, my lord, records were called for, my lord. Records have not received, but then, my lord, I've gone to the petition, my lord. Almost everything that is required is there in the petition. The petitioner in person had filed a defamation case under 499 and 500 against the respondent. And that was dismissed under 203 of the CRPC. So the criminal revision petition challenging that order, my lord, as to why that if there is any perversity in the dismissal order. Materials are there. If your lordship is inclined to wait for the records, my lord, then lordship may take date. Otherwise, I found everything here, my lord, in the petition.
Who is appearing for the accused?
Yes, on childhood record was confirmed.
Don't think she is in a position today. Here as called for has not been received. Reminder list again on.
Fixed date may be given because petitioner. Yeah.
Give the date.
I'm deeply obliged.
15 Lordship, a report was called for. We have received the report, Lordship. As per our report, however, I beg to report that the said case has already been concluded and the charge sheet has been submitted by Bautista PS charge sheet number 531 dated 25/11/25. The case law in connection with the said case has already been forwarded to the Honorable Court of Chief Judicial Magistrate of concern. Further, it is most humbly submitted that if the petitioner is able to produce valid and relevant documents in respect of the seized articles, the same may kindly be allowed to be released on Zimma, subject to satisfaction of the Honorable Court.
All right. Since he has no objection, we send it back. Magistrate will consider if he can produce the documents. Heard Mr. A.S. Ahmed, learned counsel for the petitioner. Also heard Mr. Swensel, public prosecutor. By order dated 27/11/25, a report was called for regarding the status of confiscation proceedings in respect of the seized vehicle stroke pleasure. Today, a report has been submitted to the public prosecutor by the ACP headquarters, East Police District, Guwahati, dated 09/01/2020. Wherein it is stated that the charge sheet has already been submitted by Bohisto PS CS number 501 dated 25/11/2025. Where it is further stated in the said report that if the petitioner is able to produce valid and relevant documents in respect of the seized articles, the same may be allowed to be released on Zimma, subject to the satisfaction of the court. In view of the above, this revision petition is disposed of with the direction to the petitioner to appear before the concerned court below, submit appropriate application along with documents which shall be duly considered by the learned court below, and of bypassing order as per law. The report dated 9/1/2026 be kept as part of the record.
Thank you, Your Lordship.
Can I, Anna? Ten copy of TCR was qualified along with the city, not received yet. Therefore, passing the search sheet as shown as absconder, kidnapping a minor girl, Lordship, age about 15 years. He has not received yet.
And copy of TCR not received. Issue reminder. List again on.
Check 70. Two.
Yes, what is the submission?
But in this case, petitioner name is not there in the Etahar Lordship. Kindly have a look at Etahar page 12.
Where is the scan copy?
And we have received lordship.
The record has come.
We have not gone through yet, lordship, so lordship fixed it for gone through the scan copy and lordship. The last list on admission.
You have gone through.
Not gone through yet, lordship. Fixed it another lordship, we have to gone through it.
Well, the scan copy of TCR has been received. Learned additional PP prays for some time to go through the same. Hence, list the matter again on.
Next week, Lordship, any date?
10 to lordship. Next. 10 to.
Like.
May I please, your lordship? My lord, this is a criminal petition for quashing the impugned order. My lord, kindly see the page number 25, that is annex number 4. Annex number 4, page number 25, my lord. Now the petitioner, my lord, is ready to willingly appear the trial court, my lord. There is the trial, my lord. Sure, she will appear regularly in the trial court, my lord. There is NBW and my lord PNA issued. That is why, my lord, he can't appear before the trial court, my lord. He is now ready to appear trial court, my lord. My lord. Watching the NBW and my lord PNA, my lord, he will appear. My lord, opposite what is?
I'm for the Lordship informant.
Yes. When is the next date fixed?
My lord, 21 February 2026.
Let you appear on that date. We'll keep it in abeyance till then.
If my lord thought that within 10 days, my lord, he will appear, my lord. If within 10 days, my lord, he will appear, my lord. He's ready, my lord, now. Willingly.
Heard Mr. Learned counsel for the petitioner and learned additional PP also heard Mr. So-and-so appearing for the informant. This criminal petition has been preferred. Seeking of the NBWA as well as reclamation and attachment orders dated 07/01/2025 passed by the learned special judge. Judge Pokso, South Salmala.
Pankasar.
Pankasar. Its case special within bracket capital P case number 52/2024. It is submitted by learned counsel for the petitioner that the petitioner shall appear before the learned court below in a period of 10 days from today. Having regard to the above, it is directed that the petitioner shall appear before the learned court below within a period of 10 days from today. Till then, the aforesaid PWA and PNA issued against the petitioner shall be kept in abeyance. Hence disposed of accordingly.
Right.
May it please your lordship. This is with regard to quashing of an order, my lord, wherein, my lord, as per the Assam government.
Well, respondent has entered appearance today and has sought time to file affidavit.
Yeah. So in the meantime, may I pray one thing, my lord? Let the case diary be called for, because here is a case wherein charge sheet ought to have been under 394. It has been reflected as 294, and so it was dropped.
I heard Mr. Kibuya Learned Senior Counsel for the secretary. Counsel has entered appearance for the respondent and 6. Time to file counter. There is allowed. Is the matter again on so and so? So call for the CD.
CD in connection with, my lord, PRC case number 2323 of 2021.
In connection with PRC case number 2323 of
2021.
Into.
Date to 18? 82. Deeply obliged.
Please, your lordship, this is the second time before your lordship. Earlier it was rejected. In the meantime, lordship, it has been charge sheeted, lordship. And the 4 co-accused has been granted bail by this honorable court. But lordship will kindly have a look at the orders, lordship. They also, they similar situated, similarly situated, they are also second application, lordship. It was also granted bail on the, that charges has been filed, lordship. Twenty-four. আপনি আছেন
Dispute case नहीं करे.
No, this will be
Kidnapping.
kidnapping case.
Not go before the same bench.
No, because earlier petition was rejected by this court, so it has been listed before this honorable court.
There was call for that is not received yet. Lordship.
As per the order revealed, lordship, my learned friend PP, lordship, he was there, lordship, details.
What is your name?
Well, he had altogether 4 persons are here, lordship. Biswajit Dole, Mohan Bora, Injamanur Haq, and Nitu Ahmed. Lordship will find that 4% lordship in the forwarding report, page 20, lordship. Altogether 8 persons were there, 4 with us and another 4 before your lordship, the orders I have.
How many days in custody?
Lordship, from 25/10, lordship. 95 days.
Even similar order.
Much obliged, your lordship. Much obliged.
Similar order.
Much obliged.
Matt, please, your lordship.
Lordship, this is regular bail application, Lordship, and as per the FIR, Lordship, and some fake gold and fake currency is recovered from 3%, Lordship, and public was caught red-handed and handed over the police to Lordship. And as on today, Lordship, and 86 days in custody, Lordship. And my limited prayer, Lordship, and considering the length of detention, maybe, Lordship, 86 days, Lordship. 86 days in custody and 90 days is mandatory period, Lordship. And otherwise, Lordship, the contents of the FIR does not disclose the specific, Lordship, and from whose possession this article, this currency and gold is recovered, Lordship. There is nothing mentioned specifically, Lordship. Length of detention may be considered, Lordship, at this stage. Local person, Lordship.
Yes, what is the stage of the investigation now?
This is, Lordship, recovery is made from this petitioner, Lordship. Otherwise, from where they were collected the fake currency note along with the other gold boat, Lordship, it was not applicable to SDI. As per their statement, they were instructed to deliver it to the other person, Lordship, and on that time they were caught red-handed by the public and they were sent back to police.
Heard learned counsel for the petitioner and an additional PP. Is an application under slowing, so. It was earlier rejected by High Court or?
No, Lordship, not High Court, Lordship, the learned court, Lordship. District session, additional sessions as Lordship. Additional sessions as number 1, Kamruk Metro, Lordship.
The allegations as per the FIR is that on 3/11/25, 3 persons were detained by the public along with suspected FICN and gold, in brackets suspected to be fake, boat BOAT, at Sodilapur near Army Transit Camp. On being handed over to the police, the said articles were recovered along with one suspected fake gold boat weighing 1 kg 519 grams. Subsequently, the FIR was lodged. The petitioner, you were apprehended on the spot. The present petitioner Azim Ali was one of the aforesaid persons who was apprehended. Date of the incident, the place of occurrence. Bail application submitted. Bail application on behalf of the petitioner was rejected by the learned additional session judge, Kamruk Metro, by order dated 03/01/26. However, by now the petitioner has spent how many days?
86 days as on today.
86 days in custody. And having regard to the CD, appears that possibility of submitting the statutory period is remote. Having regard to the above, the prayer for bail is allowed. The petitioner shall be released on bail of rupees 50,000 with two local securities of like amount. Satisfaction of the learned Delacca Magistrate.
Item 58.
Deeply
Arising out of said city lordship.
Obliged lordship.
Item
Deeply
58.
50, you were also on the spot.
On the spot, they were the buyers of the that gold boat lordship.
They came from
Same order.
They came from Chhattisgarh to buy the boat.
The condition to DD.
My prisoners. Here is bail application. Page 11 is the FIR, your lordship. There is 16 petitioners before your lordship. All are family members, your lordship. Page 11 is the FIR. All the families falsely implicated. Only petition number 3 and 4 they present in the place of occurrence. Page 11 is the FIR. your lordship.
Not received the case diary. Case diary not received yet.
Paid for interim because others are not falsely implicated. Because the victim already taken away the wife of the petition number 3.
Argument must have been made on the first day also.
I'll just try that.
He did not receive list. Issue reminder, list again on.
Obliged.
Twenty-three also came to the case diary.
May it please, your lordship. Here, my lord, allegation is that, my lord, these are suspected to be fake gold, my lord. And my lord, I think, my lord, possibly cheating, my lord, they did not cheat anything, my lord, anybody, my lord. And it was recovered on day 1, my lord, page 18, my lord. So
City not received.
here, and already more than a month in custody, my lord, everything recovered on day 1, my lord. And they say these are suspected to be fake gold, my lord. If those are fake, my lord, possibly they wanted to cheat somebody, nobody has been cheated, my lord. And sections attributed, my lord, are cheating, then theft and forgery. All below 7 years, my lord. 7 years and below, my lord.
And one is complaint.
No affair that these are stolen property, my lord.
Stolen fake gold. Fake gold is also stolen.
Possibly they wanted to dupe somebody, my lord. They couldn't.
Cheating when they can property handle.
Forgery, my lord, no document, my lord, no available security, my lord, that has been forged, my lord. Was rejected by the learned court, my lord, because, my lord, there was an objection that, my lord, investigation was going on. Preliminary stage, my lord. Case 39, my lord. And here, forwarding report, my lord, they doesn't say anything about that, my lord, compliance of, my lord, 35(3), my lord. Either in the forwarding report nor page 24, the order passed by the learned court, my lord, where the accused persons were produced, my lord. That is from, it starts from page 24, my lord. I've checked it, my lord. Nothing is there, my lord. Why it was not complied, my lord.
What offense is actually made out?
Exactly, my lord.
If somebody is carrying gold colored, it is only suspicion that he may be using it for something. It is at best preparation, not even attempt. Preparation, except in few cases like dacoity, not permissible. Third learned counsel for the petition. Additional PP. This is an application under so and so. As per the FIR, police team intercepted the present petitioners. At Rongya and recovered certain articles from them. suspected to be fake gold biscuits weighing 5 grams each. And as they failed to produce any valid documents, the petitioners were arrested. It is not the case of the prosecution that the accused persons were found attempting to sell the said alleged fake gold as a real gold. It is not clear what offense has been made out, if any. In the meantime, the petitioners have spent 30 days in custody. Therefore, further detention is not considered necessary. Accordingly, prayer for bail is allowed.
My objection may be recorded because Lordship, we don't know the involvement and role of the petitioners. What is
Under the additional PP objection.
CD is not here, Lordship.
As the CD has not been received.
Much obliged.
May it please your lordship. Lordship, CD is not available, lordship. I am on interim, lordship.
Available. List again on interim order.
19-2.
First letter to continue till the next date of listing.
Oblige your lordship.
In this case, I am on interim, my lord. This is an allegation that I have used one fake certificate. The report was called for, my lord. Page 23 is the FIR, my lord.
This petition is on behalf of whom?
My lord, this is Dhrubajyoti Kolita,
That is the,
petitioner, my lord.
not the PHC officials. But what is this the, this FIR is against these PHC officials, is it not? Or
Yes.
is there any other FIR?
No, my lord. This because alleged that I have used that particular
Okay.
birth certificate, my lord, in one proceeding. They allege that that birth certificate was fake, but it is the other way around, my lord. Rather, the victim, she has used the fake birth certificate in a POSCO case, my lord. Victim. And in that case, the accused has filed this particular birth certificate, which is genuine in that particular case. Then in subsequent FIR, same was against the original being used by me, madam. Show her age, madam. And this FIR was lodged.
Petitioner has produced a birth certificate showing her date of birth in the year 1997. And the victim has produced their birth certificate showing their date of birth in the year 2001. And probably they have to prove that she is a minor and for attracting the POXO cases, Lordship. But
So according to the IO, it is 97.
97. That report has both has been sent for verification, and that verification report has been come, and that is the 97 is the genuine, Lordship. Because Lordship, regarding 2001, there is no any record they found, Lordship, and 97 they have found as per their hospital report, Lordship, the T State Hospital report, Lordship. Probably it is genuine, Lordship.
Against her, already one charge sheet is also been filed, my lord, for the same victim. Wherefrom I have collected, my lord, for producing fake certificate in a POSCO case, my lord. Rinku Tati.
We heard Mr. M. Bora, learned counsel for the petitioners.
Apart from the Lordship, he was on interim, Lordship. His statement I have not found, but I have talked with the IO, and as per the IO person, also, he was appeared. But why that report, his statement is not here, he could arrest it. Yet, as per the
An application under so and so. Paragraph 3 of the bail petition. The CDS called for has been received, and as per report of the SDM and HO, Kharupetia, BPHC, the date of birth of the alleged victim, Rimika Tanti, been ascertained as 25/07/1997. Would go to show that the petitioner prima facie is not involved in submission of or procurement of any fake birth certificate in order to show the age of the victim as a major before the learned court below. Having regard to the above, the prayer for pre-arrest bail is allowed. The order of entering pre-arrest bail dated 25/6/25 is hereby made absolute. It is further provided that the charge sheet has been submitted. In this case, no.
Not in this case, in the other case.
You to cooperate with the investigation.
Ablash.
Stand back, CD.
Here in item 7, Lordship, CD is not available in our office, Lordship. ठीक है सर.
I'd still like to see some of the order I had passed. We'll take it in chamber later on and find out what order was passed. Names of the other petitioners will be there in the cause list in last 2 days. You can find out from there.
Diplomas.
Pick up this matter after some time, Lordship. And thus, MS Andas has gone through the city, sees in
Interim is there, Lordship. After interim, the petitioner appear before the IO, Lordship.
Can come? Something.
Application, Lordship.
We have not received the CD, Lordship.
Interim was there, Lordship.
They did not receive. List again on so and so interim order passed earlier to continue.
Terrible. February 13.
Yes.
In it?
Please, Lordship. Lordship, the petitioner is on interim bail, and as per direction of this honorable court, he appeared before the IO and recorded his statement on.
We have received the CD, but it is required to be up to date, Lordship.
Otherwise, on the last occasion when CD was perused by this honorable court, nothing was very specific towards the petitioner, my lord. And he has recorded his statement on 14/1/2026.
Let's see, 14/1/2026.
14/1/2026.
CD's update is 13/11/2025. And identified body was recovered from the cloth which was she is wearing. That the informant, who is the informant, her daughter was supposed to be that disease. Lordship. Otherwise, that postmortem report is not here. An inquest report is here. Girl was missing. On that day, the unidentified body was recovered. From the plot, it was identified that maybe that girl which was kidnapped.
Even the identity of the victim is not available.
Yes. From the inquest report, it was.
Let us have the updated CD.
Yes, supposed to be that girl, but it was not clear from the case diary.
Can it be on 17 or 16 February?
Updated CD is not available since. Is the matter again on
19/2.
Interim order passed earlier. Continue.
Oblige, your lordship.
In time, nothing, we have not received the case diary.
We did not receive list again on the interim passed earlier to continue.
Number 18/2.
18. Deeply obliged.
Please charge sheet subject Lordship.
Lordship, the offense is session trialable, your Lordship.
Learned counsel for the petition. PP submits that the charge sheet in this case has been submitted by
Case number 74/25 dated 30/12/25.
thereby indicating that the investigation of the case is over. There are having having regard to the nature of the allegations as stated in the FIR, considered necessary that the petitioner be remanded to custody. Facts and circumstances of the is allowed. The order of interim pre-arrest 19/12/2025 is hereby made absolute. Condition that petitioner shall not directly or indirectly make any inducement, threat, or promise to any person acquainted with the facts of the case so as to dissuade disclosing such facts.
Oblige, your Lordship.
What is also charge sheet submitted?
You will need the TCR in this case.
That's okay. If she was TCR.
Lordship, the petitioners are not at all involved in this matter.
How do we
It
know?
is only the counter plus FIR has been lost against this petitioner. And moreover, petitioner is a
Hey, you are on interim. See. Submitted by additional PP that charge sheet has been submitted by so and so.
By CS number 356/25 dated 20/12/25.
Call for the scanned copy of the TCR along with the CD. Just again on
18.
Passed earlier to continue.
Please, Lordship. 18%.
18-2. 37 Lordship, a report was called for whether any cases registered against the petitioner or not. For a report, no cases registered against the petitioner.
Learned additional PP submits on instructions received that no case has been registered against the present petitioner. At which PS? At book PS. The present application. Hence closed. The report of the OC Boko PSP kept on the record.
Obliged.
What is 482 lordship? What's the FI translated part is in page number 9 lordship. CD has been called for.
Do we have received lordship?
Yes, what is there?
As per CD lordship, this truck was booked by this present petitioner. He was the manager of the owner, and thereafter lordship, when that truck was not reached the destiny, the owner tried to contact this person. His phone was switched off, and he was not coming to his office in general lordship. And thereafter lordship, as per the CDI report lordship, he is repeatedly contact with that truck driver lordship. And apart from that lordship, that while they used to book that vehicle, they used to collect some or keep some vehicle report registration card certificate like that lordship. And in that certificate lordship, that vehicle number and the chassis number is different. It is not matching lordship. From the DTO, it has come out lordship. And materials are not yet recovered lordship. So his involvement is there lordship.
Lordship, the petitioner is the only person who used to give track. They used to ask him for tracks lordship. His only duty is to give track contact numbers lordship. Lordship, and 2 times he has been calling police station. He went also lordship. He has cooperated lordship with the police lordship. But his duty is limited lordship only to give the contact details of the track lordship. He's 21-year-old lordship.
See that
Boy lordship, no past criminal records lordship. Before also he used to give contact details lordship. Whenever they used to ask him for tracks lordship, he used to give contact details for the track lordship. Only limited lordship his duty lordship, only to give that contact details lordship. He was an employee in his father's grocery shop lordship, and as a part-time he used to give truck drivers to the people who wants tracks lordship. And whenever he was called to police station, he went also lordship.
But CD does not reflect that lordship, that he was called for and he visited the office. Yes, lordship. There is every possibility of his involvement lordship.
If you have gone to the PS and you are not arrested, then you have no apprehension.
Many times he has been called lordship, that's why lordship.
Good.
Quantity of materials.
So he is ready to cooperate lordship, 21-year-old boy lordship, no past criminal records lordship.
This is the starting point. Unless he is taken to task now, he will grow into something bigger. Third learned counsel for the petitioner, learned additional PP. An application under so and so. Page 15. Paragraph. Next of the case. Learned counsel for the petitioner submits that the petitioner is a 21-year-old boy who works in his father's grocery shop and occasionally arranges for trucks for transporting goods for different purpose. For different persons. Is in no way involved with the alleged offense. He also submitted that he has already appeared before the police earlier in this regard. Per contra learned additional PP submits that the CD does not reflect any appearance on the part of the petitioner before the police, and moreover, there is sufficient material implicating the present petitioner, the commission of the alleged offense, and the stolen goods are also not yet recovered. Having regard to the above, appears that the Real interrogation of the petitioner may be necessary. Frequently, the prayer for pre-arrest bail is rejected. Petition stands dismissed.
We have not received the CD lords.
Lordship, case diary was called for.
We did not receive
I'm
list
not
again.
on maintain, my lord. Short date may be given, my lord.
All right, short bill.
February 9. That's it. February 9.
Nice.
Please, Your Worship, we're challenging the judgment order dated 2/6/23 passed by the Family Court Barpeta here. The stay service has been completed and an affidavit has been filed. However, the respondents have not appeared till date.
Learned counsel for the petitioner. Affidavit on behalf of the petitioner regarding dusty service upon the respondent has been submitted. Wherefrom it appears that has been served upon the said respondent. However, none appears for the respondent. Place the matter for admission on
A date may be given.
Lordship, CD received, Lordship, his statement is not available, Lordship, but one bail objection, Lordship, is there, where it is stated that he is released on interim bail. His statement is not available in the case.
3 times, Lordship, he appeared before the
Yes, Lordship,
IO Lordship
sufficient
in the
materials
Becker
are
order.
there, Lordship, sufficient materials are there, Lordship. Interim may be vacated, Lordship. Kindly peruse the bail objection.
So 3 times, Lordship, he appeared, then another case was, Lordship, he was arrested, Lordship. 3rd time, Lordship, he.
There is a mountain of material against you.
The lordship, the page 20 lordships, the one lady is arrested lordships, in this case lordship, Krishna Devi lordship. I am the,
Learned counsel for the petitioner, learned additional PP. An application under so and so.
paragraph 6 lordship, page
As
4
per
lordship,
the FIR.
contractual basis lordship.
Page 16, brief facts of the case. The petitioner has preferred this bail application under apprehension of arrest as he was called by the police officers and this court by order dated 5/09/25 had granted interim protection to the petitioner. ADS call for has been received along with bail objection submitted by the IO. The result of the same appears that is incriminating material against the accused appears that played a pivotal role in commission of the alleged offences. In regard to the above and the probable need for custodial interrogation, therefore, pre-arrest bail is rejected. Order of interim pre-arrest bail dated 5/9/25 stands vacated.
The lordship, I am petition third time APL lordship, not a statement recorded lordship. So lordship. The other accused, the main accused is the bail application was pending lordship.
We are on you now.
So lordship, along with the bail application lordship, the
Yes, next item. Develop.
Lordship, as per office note dated on 21/26 year. I have to file affidavit in opposition on our condonation delay. Issue remains is that your lordship on the dishonorable last occasion, dishonorable court has directed to go for pendency cannot be a bar for the settlement if arises. So till now, there is no any communication. So having no any other alternative, I'll file my affidavit in opposition on the miss case on the next date fix your lordship. 1 week time may be granted your lordship. Otherwise, your lordship. This is my humble prayer. I have been trial court has asked for to give payment of rupees 5,000 per month from the date of filing, but till date there is no any communication, nor they have paid anything to the victim. Because my humble prayer is that 1 week time may be granted. I will file.
The petition. The respondent number 2. Stop further time to file objection as progress has been made with regard to settlement. Is the matter again on. In the meantime, respondent may file its objection.
I'm deeply obliged.
Much obliged. Lordship, in this case, notice was issued on 3rd January. Lordship, that has not been served. No report has been received by the registry of this honorable Lordship. Await service report. Look.
Service on respondent number 2 is not yet complete. Wait. List again on so and so.
All right.
Your Lordship, in this matter, we are awaiting service report. I mean, they may be allowed to take dusty service.
Service on respondent number 1 is not yet complete. Petitioner is allowed to take effect dusty service. File affidavit accordingly. Place the matter again on.
Next.
10:45.
Please, Your Lordship. My senior, Mr. U Chaudhary, he is appearing in this matter as a legal aid counsel, but due to some personal difficulty, he is not attending the court today. So I pray that the matter may be taken up on some other day.
The ground of personal difficulty of Mr. Youth. Legal aid counsel is the matter again on.
Your please.
May I please your lordship, in accordance with the last order passed in this case, the petitioner has filed an affidavit of dusty service, my lord. Lordship, the notice was received by the sister-in-law of the respondent number 1, my lord. On that day, the respondent number 1 was not at home, and on her telephonic instruction, the notice was served to the sister-in-law, who was living in the vicinity of the same house, my lord, in a separate room.
Anybody is appearing?
No, my lord. Page number 50 is the signature of the sister-in-law, my lord. The notice.
Is that sufficient? Is he member of the same household?
Yes, ma'am. Same house.
Lives in the vicinity of the house.
Yes, my lord. There are 2 parts in the same house, my lord.
Guwahati only could have gone on another day. Where is the notice that you have served?
Lordship, at page number 50 of the affidavit, my lord.
Page
Page
five.
number 50, my lord.
Does not bear any date.
Lordship, 28/11 is the date.
That is, what is the next date? That is not mentioned here. How will she appear?
Can Lordship kindly give us another chance to serve by Dusty, my lord.
Learned counsel for the petitioner. Stated that dusty service has been effected upon the sister-in-law of the petitioner, of the respondent. The perusal of the notice shows that the next date fixed in this case is not mentioned in the notice. Date to be served upon the said sister-in-law. Consequently, none has appeared on behalf of the respondent. One, petitioner is directed to effect fresh dusty service, clearly mentioning the next date is placed again on.
Hariom.
Not really. The IA has come up for consideration of the suspension of the sentence that was passed by judgment dated 7/3/25, page 50.
In this case, Lordship, we have received the TCR, Lordship. We have received the TCR, Lordship, we have received.
So,
I, Lordship, can dispose of the matter by fixing it on Lordship, because I have not gone through. Final disposal, Lordship. Then.
There was the formal consideration of the bail. For that purpose, amicus curiae was also appointed.
And 4 of POXO.
how long in custody?
My lord, since 7/3/2025 till today, my lord, he is there, and altogether more than 400 days.
70 days.
470 days, my lord, during the trial and subsequent to the judgment.
Sentence is of 7 years.
7 years. Also of the same, my lord, age of 20 years at the time of commission of the offense. It should go to show that, my lord, they had an affairs and there was no forceful physical relationship. And now only the person is the, my lord, victim herself who says about regarding this physical relationship. The conviction can be based on the solitary event, on the statement or the evidence of the victim. But for that purpose, my lord, the test of the, my lord, particular witness, the victim, has to be gone into, my lord. But if your lordship looks into the 164 statement, a different story has been projected, which is also the, my lord, version of the, my lord, PW 3, who is the mother of the, my lord, victim. But while, my lord, deposing before the court, some different, my lord, story has been, my lord, stated. And from the 164 statement, if your lordship, my lord, sees, there was the entire story, my lord, sought to be projected by the evidence, my lord, turns to be, my lord, wrong, my lord. Now, the date of incident was on 20/11/2018. Now, under the 164 statement, she said for 20 and 21st,
It is for a period of fixed period of 7 years. Hearing, we don't know when it will take place. Remember, did.
Yeah, please, your lordship. Should item may be passed on for the time being.
49.
Yes, lordship.
Who's that? We didn't know, I think he was released. Any, they made it, lordship. Yeah, they, because today, the last, almost last item.
TCR is not received, or is it?
49 with scan, 49 TCR received, lordship.
The notice on respondent number 2 not yet received.
Has to be. Service receipt, for service receipt.
As per office note, neither AD card nor unserved notice or service report in respect of respondent number 2 has been received. TCR scan copy of TCR has been received. Which service list the matter again on.
Fabulous.
May I please, your lordship? Lordship, this is a criminal petition for quashing of the DB case, your lordship, which has been filed by the daughter-in-law against the mother-in-law, sister-in-law, and 2 other persons which are the neighbors, your lordship. And the same case is pending in the Judicial Magistrate First Class Kamrup Metro, your lordship. And notices were already been issued, your lordship. And as per office noted dated 3/11/2005, your lordship, unserved registered notice has been there with a note postal report that address is not found in that address, but the address has been furnished by the victim herself, yourself, in the DV case, your lordship. Even the usual process also, your lordship, as per office noted dated 17/1/2026, no service report is there, which has been sent to district magistrate, your lordship. Reminders were also been issued, your lordship. So it has been presumed that they are misleading, your lordship, and fake report has been there. So let the matter be listed for admission hearing, your lordship.
The notice, they can take step through OC concern, lordship. So.
Postal report also there, your lordship.
Postal report.
Several times, your lordship. Reminders also several times has been issued, your lordship, to district magistrate.
As per office note, service report in respect of respondent number 1 has been received back. The district magistrate Kamrup. Date. Okay. Serve notice to the concerned. Routed through the registry, right?
Routed to the rest.
Steps to be taken within 3 days. List the matter again on.
Highly obliged.
May I proceed, Lordship? Lordship, I on behalf of my senior Rafiq, as instructed by my senior that the service report has been awaited for the respondent number 2.
Per office note is issued upon respondent number 2 has been received back unserved with postal remark. No such person in this address. So RTS So he's not there in this address. You have to find out his address. Petitioner to take steps upon the respondent number 2 after verifying the proper address of the respondent number 2. Just again on.
May I please, Lordship?
I am appealing for it.
Can you fix it on admission?
Lordship, earlier interim order was passed, Lordship. It may continue, Lordship.
Learned counsel has entered appearance for the respondent number. Is the matter for admission on Swen's interim order passed earlier to continue till the next date of listing.
Please, Your Lordship. As per the office note, my lord, notice has been received by some persons, my lord, without mentioning the relationship with the respondent number 2, my lord. As per the office note, my lord. Prakash has received the notice, my lord, for respondent number 2, my lord. Perhaps he is a relative, my lord, family not mentioned by him.
Steps then. For office note. ID card in respect of respondent number 2 has been received back. But the signature is someone called Prakash. Relationship with the respondent number 2 is mentioned. Petitioner is take fresh steps. Again on.
Hello.
The hearing matter has been fixed today.
Appeal from jail, Lordship, and if this is a appeal from jail, and I am appearing as a legal aid counsel for the appellant, Lordship. Here in this case, Lordship, appellant was convicted under NDPS Act, Lordship, and there is a total non-compliance of section 42 of the NDPS Act, Lordship. Learned Lordship, trial court has also observed that that is a total non-compliance, Lordship, but convicted on the appellant on the ground that it will not prejudice the accused person, Lordship. It will not take so much time, dear Lordship, because that is a total non-compliance, Lordship. From the evidence of the PW itself, Lordship, it is discernible that the 42 section, subsection 1 and 2 was not complied with, Lordship, while making search and seizure, Lordship. If your Lordship come to the paragraph 27 of the impugned judgment for a moment, Lordship, your Lordship will find the trial court has also observed that that is it, not compliance of section 42 of the NDPS Act, Lordship. Page 27 of the appeal memo.
Judgment paragraph?
Paragraph 24. May I read, Lordship? The instant case from the testimony of the informant Mohammad Firdaus Ahmed PW5 tape emerged that based on the information received, he made GDNT number so. However, the extra copy of GDNT was not proved during the trial. Further, PW6 Jyoti Prasad Das, another police officer who submitted the charge sheet, has stated that he has not submitted any authorization letter under section 42 of the NDPS Act along with the charge sheet.
In this regard, PW file informant police officer has also admitted in his examination chief as the matter was urgent, authorization under section 42 of the act could not be obtained. The prosecution side has also not adduced any evidence during the testimony of 5 or 6 about PW5 informants sending information received to the higher authority of police within 72 hours as required under section 42(2) of the act. In the constitutional bench judgment of the Colonel Singh judgment, Lordship, it has been held that the adequate or strict compliance to the provision of section 42 of the act would suffice. Further, it was also held in para 33 that in case of non-compliance, trial may not be vitiated if no prejudice is caused to the accused. Here, Lordship, the Colonel Singh judgment has held that the total non-compliance is not permissible. If the non-compliance with some reasonable explanation, that is permissible. But here in this case, there is no explanation from the prosecution side. Here I beg to defer the opinion rendered by the to some extent, Lordship. Yes, referred the Colonel Singh judgment, but Colonel Singh judgment does not say so, Lordship. The basis of Colonel Singh judgment, Lordship, there are another judgment of the Supreme Court, Lordship, who has, by referring the Colonel Singh judgment, the Honorable Supreme Court has held that the non-compliance of section 42 is vitiated trial and it is accused entitled to acquittal, Lordship. The other paragraph also, the trial court has held that paragraph 28, Lordship, in the instant case, the prosecution side reveals about recording of the information as a GD entry was also made pertaining to the same being GD entry number. So, however, as discussed above, there is no evidence regarding sending of information to a higher police authority, and the aforesaid GD entry extract was also not exhibited during the trial. Therefore, there is no evidence regarding compliance with the provision of section 42(2) of the Act. With regard to recording of the information as required under section 42(1), it is not a case of total non-compliance, Lordship. However, the same is not adequate. Thus, I find from the prosecution evidence that though the recovery of suspected ganja weighing 40 kg duly supported by absolute evidence from the premises of the accused has been proved, but the provision of section 42 of the NDPS Act have been largely not complied with. Your Lordship, go through the evidence of the PW 5 and 6, the case be more clear, Lordship.
Go to the LCL, TCL. If you not go to the TCL Lordship. This is the difficult.
Let me conclude my part today, Lordship. They will also do it other day, Lordship. I'll only stick with the non-compliance with the section 42 of the Base Act, Lordship. Others is that the prosecution examine as many as 7 number of witnesses. PW 1 to
We have
3.
seen the judgment, according to the learned trial court, by interpreting Rajak, said that since it is supported by independent witnesses, which was ordained in Rajak, the recovery can be believed, although 42 has not been complied with.
But the Colonel Singh says has held that the total non-compliance is not permissible, but non-compliance with some reasonable explanation is permissible to such an extent, Lordship. I have the Colonel Singh judgment, Lordship. People find the paragraph number 35. The conclusion, what is to be noticed is that Abdul Rashid did not require literal compliance with the requirements, paragraph 35, Your Lordship. Requirements of section 42(1) and 42(2)
nor did Sergeant Abraham hold the requirement of section 42(1) and 42(2) need to be fulfilled at all. The effect of two decisions was as follows. The officer on receiving the information of the nature referred to in subsection 1 of section 42 from any person had to record it in writing in the register concerned and forthwith send a copy to this immediate official supported before proceeding to take action in terms of clause A to D of section 42(1). But if the information was received when the officer was not in the police station, but while he was on the move, either on patrol duty or otherwise, either by mobile phone or other means, and the information calls for immediate action, and any delay would have resulted in the goods or evidence being removed or destroyed, it would not be feasible or practical to take down in writing the information given to him. In such a situation, he could take action as per clause A to D of section 42(1). And thereafter, as soon as it is practicable, record the information in writing and forthwith inform the same to the official superior. Here in this case, the PW5 Lordship was in the police station. He received the information at around 12 p.m. Lordship, but he did not record any information in the register. Although he, in his evidence, Lordship deposed that GD entry was made, but in later part of the evidence, he deposed that no, they went to the house of the accused person without making any JD entry. From their own evidence, there is a contradictory statement of the PW itself, Lordship, informant itself. C, in other words, the compliance with the requirements of section 42(1) and 42 in regard to writing down the information received and sending a copy whereof to the supervisor should normally precede the entry, search and seizure by the officer. But in the special circumstance involving emergency situation, the recording on information in writing and sending a copy thereof to the official superior may get postponed by reasonable period, that is, after the search, entry and seizure. The question is one of urgent and expediency. Here in this case, Lordship, suppose assuming that there was an emergency situation and they went to the place of occurrence, Lordship, without informing the superior. But here in this case, no authorization was exhibited, Lordship. Neither they, after making charge, Lordship, send the information to the superior officer within 72 hours as required under section 42(2) of the NDPS Act, Lordship. From their evidence itself. While total non-compliance with requirements of subsection 1 and 2 of section 42 is impermissible, delayed compliance with satisfactory explanation about the delay will be accepted compliance with section 42. To illustrate, if any delay may result in the accused escaping or the goods or evidence being destroyed or removed, not recording in writing the information received before initiating action, or non-sending of a copy of such information to the official superior forthwith may not be treated as violation of section 42. But if the information was received when the police officer was in the police station with the sufficient time to take action, and if the police officer fails to record in writing the information received or fails to send a copy thereof to the
So in this case, they have done nothing.
They have done nothing, Lordship. They received the information around 12. They may, according to them, they made charge at 3:30, but 12, they were, at that time he was in the police station, but no information was recorded in the GD entry, Lordship.
The entry was also not exhibited.
Yes, not
if any.
as per law, Lordship. And from their own evidence, they stated that they went to the house of the accused without making any GD entry. Your Lordship will, if you Lordship go through the evidence of PW 5 and 6, it will be more clear, Lordship. There is a contradictory statement between PW 5 and 6. They try to fill up the lacuna in the evidence, but in other part of the evidence of the other witness, they contradict themselves, Lordship.
All right, we'll continue with prosecution next day. Counsel for the petitioner. Granted additional people. Time to go through the. Is the matter again for hearing? Give a date. Five. That day you can take us to the evidence if you want. Necessary.
may keep the matter be.
Will be kept as part of.
Highly obliged.
Yeah.
We are trying to communicate, Lordship, but we are failed to receive any instruction regarding the charge sheet submitted or not. 7 days in custody as per.
Tomorrow. He submits that has not been able to obtain instruction whether the charge sheet has been filed or not and prays for 1 day's time. Accordingly, list the matter again. 29.